presentation, so if both counsel wants to see.
Welcome back to Law and Crime. I'm your host for the afternoon, Caroline Polisi, and court is now on lunch break, a lunch recess in the Todd Kendhammer case out of Wisconsin. And I'm joined here at Law and Crime in studio with Yosha Gunasekera. No, no, okay, almost. Say it again. Gunasekera. Sorry, I apologize for that.
No worries.
Thank you for coming on.
Thanks for having me.
So we were hearing today, it's not the most exciting day for testimony. I have to admit, usually I find all trials very exciting, but I have to say that this DNA testimony is a little bit tedious at times. And I don't really know, what do you think the overall, if you could, take us up to a bird's eye view, what do you think both the prosecution and the defense is trying to get out of this witness?
I think they're just trying to get all of these details, especially the prosecution. They're trying to get all of these minute details so when they close, they can bring it all together. They can say, as the DNA analysis shows you, we can prove X, Y, and Z. We can prove the events happened in this sort of way. And what's important to remember here is the prosecution has the burden of proof. So the prosecution has to go into this detail because in the closing, they can't make those quantum leaps. They can't say, okay, well, because you heard this, it means this. They have to really paint a connect the dots picture. So while it does seem very tedious, it is important for the prosecutor to go into such detail.
Right, and we're hearing all of this, again, nitty-gritty. We're getting down into the nitty-gritty of transfer of DNA, primary transfer, secondary transfer. I think what they're getting to is the fact that there was blood found inside the car and outside of the car. And as we know, the bigger issue in this case is, the prosecution is not buying the defense of Todd Kendhammer, which he says this was a freak accident. You see the car there on the side of the road. There's some evidence that, apparently a bystander saw the car there that way without the crack in the windshield. Now, obviously, one would assume that if this had taken place the way Todd says it took place, the crack would be there. But that's really not what we're focusing on today. Today, we're focused about the forensics, and there's a picture of him at the scene you see on your screen there. So what does it mean? The prosecutors are very intent on showing that there was blood on both ends of this pipe. There was blood sort of outside the windshield, and we saw in his interrogation video, they're asking, well, how could the blood have gotten there, when the trauma happened inside of the car?
Really, they want to catch the defendant in a lie. And so they're trying to get as much information out through the DNA analysis as possible to explain to the jury, look, this story, what he's telling you doesn't make sense, and it's contradicted by science. What's hard is there really is no eyewitness account of this. So it's all about recreation. And so it becomes difficult because really the only person who is left to tell the tale is the defendant in this case. And so they're just trying to poke as many holes as possible, which is why they're going into all of this detail. Whether all of it will eventually be relevant for a closing is hard to say, but they're going to cover their bases and go into all of it.
Right, which is why they really need to get really down in the nitty-gritty when they have the chance, when they have the witness on the stand. And you heard there, this witness is actually going to go review his notes over the lunch break so that he can give a more fulsome report upon his return. But to me, I'm not a DNA expert. To me, the issue of where the blood was found, on which objects, I don't know if that's going to be sort of the smoking gun in this case, because the way Todd lays it out, there could be blood sort of everywhere in terms of, because he said that he dragged her body out from the car, tried to resuscitate her. Who knows what was going on at that scene. Of course, I think the prosecution is trying to paint the picture that, look, these injuries occurred outside of the car. In fact, they confronted Todd with that theory, and that therefore that's why there's so much blood here. Do you think that the jury is going to sort of hang its hat on the testimony of this DNA expert?
I don't think so. I think it's just one small part of a larger picture. I think the prosecution has an uphill battle based on, what we know about the case so far. So I think they're trying to throw everything at the wall and see what sticks.
Right. We heard earlier from Trooper Michael Marquardt. I don't know if you've heard his testimony, but he he recreates accidents of this nature to investigate whether or not any criminal activity potentially took place. And so I liked that witness a lot. He talked about sort of he uses Sir Isaac Newton's physics when he recreates these accident scenes, and so he testified to sort of the velocity at which the pipe would have had to have been traveling. Do you buy it? Do you buy the story?
I think it's hard to recreate a scene completely. Science, forensic science, is constantly changing. We can look at cases that were done 20 years ago, and the science, which seemed ironclad then, is now completely wrong. So it's very, very hard to recreate the crime scene, and I think the prosecution is really trying to fit a certain story. They have a narrative of what happened, and they're trying to make the facts fit into the story, and they're using these individuals to kind of paint that picture. So I think it's hard. I think no one's going to be able to recreate it completely accurately.
Right. Which I think the defense really hammered home there in asking questions like, well, you don't know, for example, the speed at which this truck was heading in the opposite direction, and you don't know, you're assuming that it was 6 feet up when we're not really sure the height of the truck bed. I think it's harder now, the prosecution, they're not really putting forth a case of what happened, they're trying to disprove a case, which I think is even more difficult because there are so many variables. And of course, the ultimate defense is, look, this was a freak accident. And, Todd, I will say, watching his interview, did you find him to be credible?
I think, again, as we've spoken, it's really, really hard to say how you would react, especially in a case where it's such a freak reaction. And I think what's interesting and kind of scary about this case is a lot of it is moving forward on assumptions.
Yes.
The crime scene investigation, we're assuming a lot of things.
Yeah.
Which is scary in a case where, someone is facing such serious repercussions. And that's what the defense is going to hammer home again and again. And while they'll probably bring in their own forensics experts, I think they're going to say at the end of the day, we just don't know what happened. You have to take into account the only person who was here who experienced it and his story. And yes, it may not completely make sense, but how he reacts to trauma and how you react to trauma is different. And none of us have been in that situation, and none of us can say how we would react.
Right. Speaking of the only other witness to this crime, Todd, rumor has it he may take the stand in his own defense. What do you think about that?
So that's a very interesting issue, and it's an issue that every defense attorney has to confront. So one of the things is to make sure that he comes off as credible, because he has a constitutional right to testify or to not testify. And generally in voir dire, that is one of the things every defense attorney wants to hit home, that, if he doesn't testify, you can't infer something negative. You can't think that, he's not testifying because he's hiding something. But it's hard.
But in reality, we all know,
Exactly.
A jury wants to hear from the defendant. It's just human nature. You see this person sitting there throughout the trial. You want to hear from that defendant, right?
But it's tough because it's a catch-22, right? Because then he testifies and then everyone on the jury is saying, oh, well, he's just testifying to save his own skin. So it becomes difficult because it's a little bit of a tough situation whether he testifies or doesn't testify. But I think in this case, it's helpful with individuals who don't have a previous criminal record, because generally if someone has a previous criminal record, that's something that prosecutors will definitely bring out. But in this case, it's going to come down to credibility, and I think it would be interesting for the jurors to be able to hear what he has to say, and if he comes off as credible, could really help him in this case.
I agree with you. I think one of the key missing pieces in the prosecution's case here is the fact that they don't have a motive. Todd doesn't have a history of domestic violence. By all accounts, this was a very happy couple. They were married for 25 years without incident. I think Todd says during one of his interviews, he said, go looking for any evidence of, we never even raised our voices with each other. We didn't have a single fight throughout this 25-year marriage. Why would I commit this horrific act? Now, you and I both know as attorneys that a motive is not an element of the offense that the prosecution has to prove, but we also both know that juries want a motive. What do you think that does to the prosecution's case?
I think it really humanizes the defendant in a way that the prosecution doesn't want. I think they want to pin him as this cold-hearted killer who found a very unique way to kill his wife. I think what's also going to be important with Todd testifying is that he can explain away some of the other negative facts about the case, like where they were headed, why his wife wasn't at work that day, and kind of create a clearer picture and tie up some of the loose ends that the defense could face.
Right. What do you think about that alibi? I mean, they were on their way to fix the windshield. Of course, it doesn't add up. I mean, that's not good.
Yeah, it's a little confusing, and so I think really maybe the only person who could clarify that would be Todd. I mean, it seems that, they were trying to go get the windshield fixed, and then they said that there wasn't actually an appointment to get the windshield fixed. I mean, maybe Todd can say, normally we don't make an appointments. I know one of the other guys at the store, and he's always like, it's a walk-in basis. There's just because things don't initially make sense doesn't mean that there isn't actually a plausible explanation.
Right. So take us behind the scenes of sort of how a defense attorney prepares his or her client for getting up there on the stand. What do you do to prepare them for that situation? It's unlike really any other situation likely that they've ever experienced before. It's a difficult place to be, and some defendants really do not do well with it.
So prosecutors and defense attorneys both prepare their clients or their police witnesses, and sometimes jurors are really surprised when they hear that because they think that it's just this person who goes on and tells the truth. But police officers and defendants are both trained, and they review the questions with the attorneys. And it's oftentimes a question that either the prosecutor or the defense will ask. So when Scott testifies, the prosecution is definitely going to say, did you go over your answers and questions with your attorney? And that answer is going to be yes. And then, again, the jury is going to be reminded that this is commonplace. But to prepare someone, you want to go through their story and you want to make sure that everything makes sense. Because as a defense attorney, you don't want to be in a situation where your client is going to perjure themselves.
Right.
And if you think that your client is lying or there's multiple different versions of the story, that could present an ethical problem for a defense attorney and really could, cause a defense attorney to say, look, I don't think you should testify because you could be opening yourself up to, future charges. So that's kind of one of the base things that you get down and out of the way. But then again, it's just practicing the questions because anybody would be nervous. Public speaking, I think, used to be, or maybe still is, the number one fear. So even someone who is completely 100% innocent could come off as guilty just because they're nervous.
Right, right. So very interesting, you mentioned putting yourself in sort of an ethical quandary as a defense attorney, but you also mentioned the fact that any defendant has this constitutional right to take the stand. It's not like we as defense attorneys have that final say. We all know if your client wants to take the stand, you have to let him or her. So what do you do in the case where you strongly disagree with that choice and yet your client wants to take the stand?
It's a tough decision. I think it's not something that can happen overnight. I think if you, as a defense attorney, and your client disagree about whether the client should be testifying, that has to be a conversation over many days, many weeks, because the repercussions are very serious. And I've seen cases where, the client defendant has testified against the wishes of the defense attorney, and it has blown up. And usually it's bad. Usually it doesn't go well. I think defense attorneys, especially experienced defense attorneys, have an understanding of when it is good for their client to testify, and really they have to strongly recommend. But as you said, it's the client's absolute right, and they have to go in knowing that their testimony may hurt them.
Right. I think it cuts both ways. I think honestly, we as defense attorneys, are sort of reflexive answer to that question is no. It's always going to be a no. It's kind of common knowledge in our world that, look, you don't put your client up there, you don't open the door to prior bad acts, you don't let him or her get the story messed up. But oftentimes, there could be an exception to that rule that I think sometimes we overlook, which is why we need our clients to say, hey, in this instance, I think that it could behoove our case. Specifically in this case, what do you think? I mean, we're not sure whether or not this defendant is going to take the stand, but if you were his defense attorney, what would you advise?
I think it's hard to tell. I usually wait until the end of the prosecution's evidence because I think you need to see how everything comes in, because at the close of the prosecution's evidence, if you don't think they've made their case, then it might not be in your client's best interest to testify. Because at that point, your client just could mess things up. And I think one of the other side of the coin is not just the client telling his or her side of the story, it's really preparing them for the prosecution's cross-examination, because it's tough. And that's where things can crumble. I feel like I'm an attorney, but if a DA cross-examined me, who knows what I would say, because it's just an intense, scary atmosphere, and they're really trying to trip you up. And in a case like this, where it's really going to come down to some of the details, he was in quite a state. So he might not remember things, or his memory might be hazy, but the prosecution's really going to capitalize on those inconsistencies. They're going to say, okay, well, you just said this in cross-examination, but when you were interrogated, you said this, or on, previously you said this, or this doesn't match up with the DNA evidence. And that's going to be really scary and difficult to overcome for the defense.
Right. In some ways, I think he does sort of have the ultimate trump card in that if this were a freak accident, as he alleges, he may not very well remember what transpired. I mean, that has got to be, if it happens the way he claims it happened, that has got to be a traumatic event. And I think that the jury would easily understand that he may not remember all of the events leading up to it. I think where he gets himself in trouble in that in his police interrogation, and we're going to show a clip of that coming up, where he gets in trouble is that he stated that he does remember seeing the pipe coming off the truck. I thought it sounded, at first he says it was a bird, he thought potentially it was a bird. I thought that sounded plausible, that sounded believable, because, this would have been just split seconds having gone by. So, when he gets up on the stand, he has a plausible defense of I don't remember, whereas in some other cases where there isn't this traumatic event that is alleged to have taken place, the I don't remember defense doesn't work as well. Here I think it may work. What do you think?
Yeah, I think it's tough, because I could also easily see a jury saying this was such a freak accident, why don't you remember? This stands out from anything else that you have ever experienced, and because of that, you should remember. And I think it's tough. I think a human memory has inconsistencies all the time, and whether he's penalized for that, I guess, is to be seen.
Right. I want to take viewers into a little bit of that police interrogation of Todd Kendhammer. We're going to analyze it when we come back, so take a look.
So your wife's gonna get done at 2:30 on Friday, okay? And you weren't gonna leave directly from school because she's got a lot of packing to do.
Wait, something to finish.
Yep, so we got a lot of packing to do.
Yeah, and it was raining.
Yep, and it was raining, so you're not gonna leave at 2:30. She gets done at 2:30. It's gonna take her a period of time to get home, so you're looking at 3 o'clock.
Yep.
Then you gotta pack.
Yep.
You gotta do all kinds of stuff. So now
You're up doing setup, and you're wondering how I'm gonna get to work, right?
You're not gonna get to work.
Right.
You know you're not gonna get to work.
Yep.
You're never late.
Yeah, I am.
No.
I've got several points on my attendance
You're
record.
a pretty good employee, according to them.
No, I've got 5 points
Why
on
would
my.
they tell me that?
I can prove it.
Prove what?
Okay, that I've got 5 points.
I
on
don't
my
care if you have
attendance.
5 points or not. You're not going to make it back in time for work
I
at
understand
6:30.
that.
You're not going to make it back by.
And I've got days to call in for sick days.
You didn't call in sick.
I don't
You
have
went
to,
ask
otherwise
you because,
no.
but
So
you haven't called in sick. You called in sick 5 times this year, only.
only that's.
All right, we're going to have to cut that clip a little bit short for you because we're about to go live in the courtroom of the Xavion Dobson trial out of Knoxville, Tennessee. The judge is on the stand.